Thank you very much, Commissioner McGrath, for these insightful remarks. And now let's start with our first panel discussion. In our first panel, we will discuss the role of the European Data Protection Board and the European Commission in ensuring coherent supervision. The discussion will be moderated by my colleague Elena.
Thank you very much, Isabel. Good morning also from me. My name is Elena Kuremenu and I am Policy Officer for Data Protection at Bitkom. I would like to welcome you to the second day of this year's Privacy Conference. It is my great pleasure to host the first panel of the day. The panel will discuss the challenges involved in ensuring consistent application of the GDPR across the European member states. We will also evaluate the changes involved in the omnibus of this year and consider future alignment. These issues will be discussed by three distinguished panelists. Today with me in the studio, I have Zenner, Head of Office and Digital Policy Advisor to Axel Voss, Member of the European Parliament. And also with us, we have Mr. Carolina Foglia, online with us, Head of Sector Secretariat at the European Data Protection Board, and Gabriela Mercuri, Managing Director at Scope Europe. Thank you very much for taking the time to be with us today. And let us dive straight into the discussion. 7 years after the GDPR came into effect, uniform enforcement is still being hindered, particularly in cross-border cases between European member states. Looking ahead, I would like to start with you, Ms. Foglia. What are the European Data Protection Board's main priorities for the coming years to strengthen coherence and improve enforcement?
Yes, thank you very much and good morning, everyone. Thanks a lot for the invite. It's really great to participate to this chat. And as I know, we don't have a lot of time, I'll just dig directly into the answer to this first question. Very happy to engage with all of you in the conversation. So indeed, as also Commissioner McGrath was mentioning earlier, there are indeed multiple challenges ahead of us and also multiple challenges I believe we've tackled already. Starting off with enforcement. You may remember that in 2020, the Commission had flagged some issues with the strength and efficacy of the GDPR enforcement. But then in 2024, in the second evaluation, the Commission acknowledged a substantial improvement of this. So looking at enforcement, I think we can bear in mind a couple of elements. Of course, in 2020, the EDPB noted already back then the difficulties linked to the difference among national administrative rules. This couldn't have been solved by the EDPB, so what we did was issuing what we called a wish list in 2022 for a further harmonization, and the Commission acted on this to make a proposal for the procedural rules regulation. As you know, this will be hopefully soon adopted and published. There will be a 15-month implementation time, and we consider this will bring already a very important further improvement. We're already working, of course, for the practical implementation of it. Since 2022 in particular, though, we can also remember all the other initiatives that the EDPB developed to support enforcement and kind of strengthen also the cooperation between DPAs. And I think we've observed very clearly the increase of cross-border cases. We're now not far from 22,000 final decisions in total, and there's a much stronger use of the tools for cooperation and the imposition of corrective measures. Looking at consistency in terms of the substance and application of the GDPR, clearly the GDPR created a level playing field for businesses and improved the consistent application of the data protection rules in Europe compared to the directive, for instance. But the Commission reported there's still room for improvement because there's sometimes a divergence of interpretation by DPAs, which is causing legal uncertainty. And really the Commission is calling to resolve diverging interpretations of the GDPR between DPAs, also including between authorities within the same member state. And at the EDPB level, we're planning a lot of actions to try to address this as a main priority, as consistency is the main mission of the EDPB. You may know that in July, we issued what we call the Helsinki Statement, which came a bit to complement our strategy for 2024-27, where the EDPB agreed on a number of measures it intends to implement to enhance consistency, and also to empower responsible innovation and reinforce competitiveness. So I would say these initiatives have all these goals combined. Some examples are there will be specific efforts to really align national and EDPB guidance, even more than now, where there are inconsistencies identified, and also a prioritization of preparation of position at EU level first to ensure consistency by design. And we also plan to follow up on guidance and to ensure their effectiveness and enable stakeholders to flag inconsistencies found. More generally on stakeholders, we've identified the need to enhance our stakeholder engagement. And so while up until then we've organized stakeholder events and public consultation on our guidelines, we will start further new initiatives, organizing also more opportunities for early engagement. And public report on the main outcomes of public consultation to also increase transparency. Two more challenges, one of which was also mentioned by Commissioner McGrath earlier, are first of all the need to find solutions to facilitate cooperation between different types of regulators across regulatory fields, and also cooperation at the international level. So from our side, we're active to find solutions to further develop these two types of, let's say, external cooperation among authorities. And then as a last challenge, I would like to mention the lack of sufficient resources for both DPAs and EDPB. This is also something that was flagged by the Fundamental Rights Agency report of 2024, and there's really a genuine need for DPAs and EDPB to have sufficient financial and human resources to maintain a high level of protection of personal data, properly deal with the additional competencies as well, and also to allow DPAs to engage more with companies and have initiatives like sandboxes and this type of, very useful initiatives. This would be it for now. Thanks a lot for the question.
Thank you very much. And I would like to now go on with you, Mr. Zenner. From the Parliament's perspective, how do you evaluate these initiatives that Mr. Foglia said before? And also, what are the biggest challenges in the consistent enforcement of the GDPR across the European member states?
Yeah.
And what should, in your opinion, be prioritized in order to better serve both citizens and organizations?
Yeah, good question. And first of all, many thanks also for the invitation. And I very much agree basically with everything my co-panelist has said before. So what I try to do in my short statement is maybe complement it. Indeed, as coming from the Parliament, we have maybe a few additional priorities, but in particular, I would like to really take a, let's say, big picture approach and combine also the GDPR with other recent legislation, because in particular on the AI Act, where I worked a lot on, we were actually trying to learn a little bit from past mistakes or certain things that didn't work like planned in the GDPR. And let me maybe start with one point. Gabriela was also saying guidelines, interpretation. My boss, Axel Voss, for many, many years was criticizing, especially here in Germany, that all those state DPAs are going in different directions. There are very different interpretations of certain parts of the GDPR in different member states. In the AI Act, as I teased already, we added Article 96, which is giving the Commission the power. They have this power anyway, but we wanted to make it really clear that they can come up with important guidelines. For example, what is a substantial modification? How is the relationship to sectorial laws and so on? So I think this in a future GDPR reform or certain, let's say, discussions, what we can improve, it would be extremely helpful to really streamline guidelines, who can do those guidelines, EDPS, EDPB only, if the Commission maybe or EDPB, EDPS can talk stronger and stricter, maybe also with member state authorities. Again, we have in the AI Act Article 66, Union Safeguard Mechanism. It's something that is fitting very, very good in product safety legislation, not in something like the GDPR. But the mechanism that allows the Commission, again, in situations where all the interpretations are going very far from each other, is, I think, something extremely important. A second point that my co-panelist was also mentioning already, capacities. We see it again with the AI Act, for example, that the poor people in the AI office are really struggling with all the tasks and so on, and they have now way over 100 people. The same can be said for DSA, DMA enforcement. And of course, we all know it that in particular, certain member states in the southeast of Europe, they really struggle until today to build up functioning DPAs with enough capacity. So this should be definitely another priority to help especially those member states, but especially on the European level, make sure that maybe also the EDPB, the EDPS are getting a bit more people, in particular for the bigger cases. A third point, I will do 4, is coordination. Also here, I spoke already about Article 66 in the AI Act, but also the whole AI office and AI board as an addition really try to tackle this problem that we saw in the GDPR, that certain mechanism, in particular consistency mechanism, didn't always work. Again, it's a different type of law, but there in the AI Act, but also in other digital laws from the last years, we added a lot of additional coordination mechanism, and there in a future GDPR reform or discussion, hopefully some of those ideas would also make it. And the fourth point, it's really something for the future. The Commission is planning next year to do a long study on enforcement problems and governance problems. As you all know, we have now way over 100 digital laws coming from the European Union. As I mentioned already, all with very different governance and enforcement approaches. Probably there is some room to merge maybe different governance mechanism, something my boss and I and parts of the Greens and Liberals and so on are pushing for, is this idea of an digital enforcement agency in Brussels with high capacities, of course not taking all the power away from member states, but really focusing on big cross-border cases that again are difficult to enforce if you are a small member state with maybe just 5-6 million citizens and so on. So those 4 points are already now heavily discussed. And again, I think the Parliament in particular would really like to learn from past mistakes and use those new tools that we have integrated in newer digital laws, maybe then in the future also for GDPR.
Okay. Thank you very much. I wanted actually to go on with you, Ms. Mercuri, but I would like to ask something about it. I think what you said before, the authorities, the European authorities, I mean, we also play a big role in the new regulation about the enforcement. And okay, we will go back on it and the cross-regulatory challenges. I would like to go back to the enforcement and ask you, Ms. Mercuri, as a monitoring body, in which areas do you most often encounter diverging interpretations or enforcement practices? And what impact do these inconsistencies have on business that are seeking legal certainty?
Hello, first, sorry, good morning, and thank you so much for the invitation. Pleasure to be here today. And I guess for starters, as the meaning of monitoring body is not so self-evident yet, but we are working on it, on building this awareness on how monitoring bodies and more broadly codes of conduct under the GDPR can meaningfully support the proper implementation of its provisions. So let me give you a very quick introduction. For those who are unfamiliar, so Scope Europe is a Brussels-based organization established specifically against the context of GDPR. And with that, the goal was to act as a monitoring body of codes of conduct, but also to host the development, negotiation, and implementation of these tools. And today we are the accredited monitoring body of two different codes, one at the European level called the EU Cloud Code of Conduct, and the second, which is the Data Pro Code, and that is a national code in the Netherlands. And next to this, we work with other industries that are in the process of developing and negotiating codes with their respective DPAs. So against the background, we were able to build quite unique expertise in the field, especially considering that there are very few codes out there up until this day. And although you might think, you say, Gabriela, but this is such a niche scenario, after all, GDPR codes are not as popular as you think. And you are not wrong if you're thinking that. But I believe you will find that our experience illustrates quite well some of the key structural challenges. So to start, I guess, with the usual suspect, which is harmonization of legal interpretation. I could go into asymmetries on specific provisions that arise within the scope of the negotiation of a given code. But I would like to use a broader example, which is a fundamental point, which is the discrepancy in the understanding of the role of codes of conduct in the first place. So I believe GDPR itself and the accompanying EDPB guidelines, which are very good on codes of conduct and monitoring bodies, they are quite clear on the fact that these tools are there to specify its provisions within a specific context. So the goal is to create the necessary specification to allow this principles-based regulation to be applied in practice. And in other words, to create guidance to translate those vague provisions that are vague for a good reason, to stay future-proof, but to translate those into appropriate technical and organizational measures for a specific sector or processing context. And despite this clarity, what we see is that DPAs still perceive these tools quite differently, depending on their legal tradition, familiarity with the approach. Of course, resources is a big factor there as well. And there's often a lack of this core understanding that codes are not there to replace the legislation, nor the monitoring body is there to replace the DPAs, but rather this framework helps proper implementation and enforcement because it enables extensive documentation of compliance and can establish robust industry standards. And those standards are built in close cooperation with the authorities. It's a very well established framework under the GDPR if you compare with other legislations, because the code needs to get the green light from the authorities as a meaningful exchange to reach that finish line. And this is why we talk about co-regulation. So, and the lead authority remains involved. It's about ongoing compliance. So the monitoring body has to regularly report obligations, has regular reporting obligations towards the authorities. So it's not about pure self-regulation, let the industry regulate itself. Definitely not the Wild West here, but these codes are a product of very robust processes that can be beneficial for all the parties involved. And considering this robust process, what can we improve to have more foreseeability, to have more codes coming to life? So for this to happen, there's a long procedural road. For the approval under Article 40, you need the accreditation under Article 41, and those are tough processes, as they should be. But very often there is a lack of harmonized and well-established procedures, which can really outweigh the incentives for the industry to engage in this exercise. So even if we look at the UCloud CUC, which is the most successful experience so far, the official approval took about 4 years. And back then we thought, okay, this is the first one. But what we see is that so far we still observe quite similar bottlenecks in this approval and accreditation processes. So the inevitable result is that many players either don't have the resources to contribute or become frustrated along the way, especially when they don't fear fines. That's an issue that we obviously need to look at. So I know this might sound a bit discouraging. I could go into some other points, but for time's sake, I think what we see, despite of this challenging road and how many things we can improve along the way, what we see, what we experience is that when they do reach the finish line, the benefits are absolutely worth it in terms of harmonization within a certain sector. And again, very well developed framework, but it's underutilized up until now. So I guess in our field, this is the biggest structural challenge.
Thank you very much for your perspective. You mentioned that the task of the implementation is a bit difficult, and that the guidelines of the European Data Protection Board have been very helpful for you. And building on this, I would like to go on and look at the cross-regulatory challenges. And in this context, Ms. Foglia, back to you. I would like to ask, do you consider to be which do you consider to be the greatest risks of this regulatory fragmentation? And how can the board contribute to building a more coherent and coordinated framework?
Many thanks. Yes, indeed, as I was hinting at in my first reply, this is really a key challenge and a very big part of our activities right now. For sure, the presence of several EU laws applying simultaneously, let's say with GDPR, definitely creates challenges and risks in terms of legal certainty and predictability in the digital field, and also increasing tasks for authorities. So both of these aspects are to be taken into account. Of course, data protection issues are increasingly intersecting with competition law, consumer law, digital markets rules, electronic communications regulations, cybersecurity. In some cases, our DPAs are tasked with enforcing rules in some of the digital legislation. From the EDPB side, we are carrying out, I would say, very important work on cross-regulatory interplay to ensure consistency and predictability of the application of these different legal frameworks. For instance, today at the EDPB plenary, we have on the agenda the guidelines on the interplay between the GDPR and the DSA, Digital Services Act. But more broadly, what is really key in my view is the engagement between regulators. There's really a need to continue working on fostering more and more structured cooperation with other regulators, both at European level, but also between specific national authorities where necessary, and face together the challenges that exist for this cross-regulatory cooperation, both from a legal point of view, but also a practical point of view. Some structures for cooperation are created by the new regulations, so to speak. So we have DMA high-level group, the European Data Innovation Board, DSA boards, and so on. And for sure, the EDPB is participating actively in all these fora to ensure that the dialogue is ongoing. But we also went a bit beyond what the law is foreseeing, because we took the initiative together with the Commission so far, as also the Commissioner was hinting at earlier, we took the initiative of preparing joint guidelines, because we thought this can really help legal certainty and predictability, because joint guidelines come already from at least two regulators at the same time, which can help indeed the interpretation. So we have ongoing work on guidelines on the interplay between the DMA and the GDPR, done together by the EDPB and the Commission, and also on joint guidelines on the interplay between data protection laws and the AI Act, together with the AI Office. This work is ongoing. We also consulted other regulators in the context of our own work. This happened in the context of, for example, the consent or pay opinion and the AI models opinion. So we've engaged also there in a dialogue with other regulators. And we are working on supporting the possibility to address the practical challenges to cross-regulatory cooperation on concrete cases. Again, in the cross-regulatory field, we will work on a common template for data breach notifications for DPAs in order to ease the burden for organizations and possibly providing support of a cross-regulatory notification solution. All in all, I think each actor is playing its own role in this complex environment, but we have to ensure that the legal framework remains predictable and clear for stakeholders. And so we are serving as a place for dialogue between national DPAs and the Commission, but we also try to serve as a place for dialogue more broadly than this. So we will proactively invite other regulators, and we will continue our work in engaging with other regulators and also working in this EU fora that I was mentioning earlier. And so I believe all of these initiatives combined can really help in the next few months and years, help increase the legal certainty and predictability that to some extent we have been maybe missing up until now, but these are the initiatives that we have put in place and we are working on. Many thanks.
Thank you very much. And now that we're talking about the initiative of collaboration, I would also like to ask you about how can the Parliament foster collaboration with the other European institutions?
Yeah. Here we are very much in line actually with you, Bitkom, and also Digital Europe and Business Europe and Axel, Voss and I, but also our group, EPP or CDU here in Germany, have for a long time now underlined that, well, we have clear rules, clear procedural rules in our better regulation framework that would actually prevent overlaps in most cases. But unfortunately, as also Mario Draghi and Enrico Letta were underlining in their reports, the European Union didn't really stick to many of those better regulation principles. For example, something is often not very good for stakeholders. Consultations are being shortened, are being put over holiday periods. Also other procedures are overlooked, impact assessments are not being done, and so on and so on. So I think the main message that all three main, let's say, EU institutions that are responsible for the legislative process, Commission, Council and Parliament should take from Draghi and so on, is to really go back to the better regulation agenda, because again, it's all there, and if we would stick to those rules, it would be much better. Now going to the Parliament, what we can do and where I see some improvement, the Parliament changed their rules of procedure, and there is now the possibility for ad hoc committees, thinking of Green Deal legislation, data strategy, Data Act, AI Act. It's always the case that there are many committees that should be at least partially responsible, and you saw it with the AI Act. We had the INCO committee, the Libe committee, in the end 24 MEPs talking with each other, also other committees still adding something. In the future, hopefully we will use the ad hoc committees to have a smaller group that, however, is still in contact with all those people that have something meaningful to say from different committees, and hopefully combining different voices. A third point is hopefully, again, all EU institutions not only stick to better regulation rules, but also just take a little bit more time. Even with the AI Act, Axel, Voss and I, we never really understood it, why it needed to be finalized before the European election. Many laws in the previous election cycle have been finished directly after the election in 24, and this gave the technical teams, so people like me, enough time to improve the last or fix the last problems. So this, I think, would be also a major point. And finally, well, everyone is talking about AI, and AI actually could help a lot in order to make better laws. Our European Parliament Research Service is finally looking, for example, into chatbots, into other Gen AI tools in order to look for patterns, for overlaps. My favorite example that I'm always giving is open source definition. There are 4 definitions in 3 laws, AI Act, PLD, CAR. They are all overlapping, contradicting, and so on. This example I know, but there are many other examples where maybe AI plus researchers can help us legislators to identify those points and then hopefully also fix those. And this will help us tremendously also with enforcement problems.
Thank you very much. And I would like at this point to discuss a bit, you mentioned the Draghi report and all the new digital regulations, and I would like to ask about the omnibus. And if are there planned any broader changes in the GDPR or the other digital regulations that aim to reduce bureaucracy and foster innovation, as we say?
Yeah. Yeah, so at the moment, I think no one, maybe except Ursula von der Leyen, our president in the Commission, really knows where the digital omnibus is heading. We are hearing a lot of different things from within the Commission. There was some talk about a long list of 85 items that they want to fix from all across the digital policy field, from CIA, Data Act, Free Flow of Data Regulation, and so on and so on. The last days I saw some other papers where it was mainly 4 or 5 categories and a smaller amount of digital laws. Personally, and Axel Voss supports this view, I think it's better to really focus on a small amount of issues and also laws, and maybe later on do a second round or something like that. I would not agree, and this goes a little bit back to the struggle from different committees that are responsible for different topics and need to work together. Think about a digital omnibus that is merging, let's say, notification obligations in cybersecurity law, GDPR, AI Act, DSA, and so on. It would mean 6, 7 committees would need to work together. Probably it will not work in practice. So maybe the outcome is even worse after the digital omnibus. So yeah, my hope, and at least right now, it looks like the Commission is going in this direction, make small clusters of really interconnected fields where working groups in the Council, but also units in the Commission are already closely cooperating. And maybe my boss, of course, would like a bigger GDPR reform, but this should be really not a part of this fast digital omnibus that was again pushed through the pipeline. We should have maybe waited a little bit more. So with a real GDPR reform, if it ever comes, we should really take much more time and also wait for the fitness checks that the Commission wanted to do, because this fitness check will deliver a lot of data that we need in order to make evidence-based policy changes.
Yes, thank you very much. And we do not have so much time left, so I would like to also hear 2 sentences from you, Ms. Mercuri and Ms. Foglia, about the omnibus. Ms. Mercuri, you can start.
Yes. I think it's, indeed, it's a quite complex discussion. At the end of the day, we are still in the process. If we look historically, this is a very new piece of regulation, but everything happens so fast, and obviously technology is evolving so fast. So it does force all the regulator to respond quickly to that and adapt and so forth. But at the same time, I think it is important to give the time to solidify a certain regulation. And we clearly see on the several examples when it comes to implementation that there's still a long road to go, and that's fair enough. Again, it is new. It is about also public awareness of these fundamental rights, and there is again a long road. So trying to not go into details in this response, I would just say that I think it's legitimate that the effort to adapt and to quickly respond to an evolving landscape, but at the same time, we must be careful and look at the tools that we already have at our disposal to improve implementation. And of course, I'm absolutely biased to say that, but like codes of conduct, let's try to harmonize implementation. Let's try to make sure that we foster accountability, transparency, and that we make this whole endeavor more understandable for the larger public, especially if we are talking about regulating very complex technologies. They are basically a black box for most So it is, I think it's absolutely understandable that it takes time to set up this whole structure also in terms of enforcement. And let's not forget that in any other file, not only on our digital files, that, yeah, finding harmonization across all different member states is a challenge. I mean, you all know very well. So I think a lot of the difficulties that we face, they were foreseeable from the beginning. So we need to really evaluate when and where. And yeah, I think that's to keep it in a nutshell. Trying, sorry.
And Miss Foglia, one sentence about it.
For sure, yes. Maybe it would be a long sentence, but still, we'll keep it super short, I promise.
Thank you.
So on the omnibus and more generally on the, let's say, simplification wave, I think the position of the EDPB and the EDPS was rather clear in the joint opinion issued on the 8th of July, that we support the general objective to reduce administrative burdens for companies and for SMEs and SMCs, as long as this objective doesn't result in lowering the protection of fundamental rights of individuals. So I would say our position will really be based on what specific possible modifications will come in the future and whether they affect the core principles of the GDPR and the protection for individuals. Meanwhile, and while we, let's say, discuss all of this, as we were saying, we have to make use of the tools that we have. And we have many initiatives that the EDPB committed to in this Helsinki statement that are really aimed to empower responsible innovation and reinforce competitiveness. So we will further we have further committed to providing practical, concise, accessible, simple guidance in a way, depending on the audience, and also complementary formats. And we will also continue our commitment as to co-regulatory tools. As Gabriela was mentioning, we have taken note of some of the concerns that have been expressed, and we will try to improve the processes and so on. Also, Article 64.2 by the EDPB, I think, can be an example of how DPAs and the EDPB can support innovation, trying to build, let's say, EU view prior to enforcement actions. And so I would say my thinking is, for sure, this discussion needs to continue, but right now we need to make use of the tools that we have in the best possible way, and the EDPB is definitely committed to doing this. Thank you very much.
Thank you very, very much, the three of you. I think that we covered a wide range of topics today, and if we had 2 more hours, we would go on. And yes, I would like to move on